Good morning to all of you. The court will note that this is a continuation of the evidentiary hearing commenced on March 7, 2023, continued on March 28, 2023, and then continuing to today's date. When we left on the March 28th date, Mr. Schaefer, you were engaged in the direct examination of your client. Are you going to continue that?
My notes indicate that we had completed that we had Mr. Tabaka on my cross of him. That's my notes.
Well, we'll check with Mr. Lane. I have in my notes, Schaefer still on direct with plaintiff, so I don't have Mr. Tabaka on at all on the 28th. Ms. Lane, what's your recollection as to what happened when we concluded?
Yes, Your Honor. Good morning. I believe that Mr. Schaefer had indicated he was finished with his direct examination of his client, and we had skipped his cross-examination of Dr. Tabaka because we were to provide the supporting calendars and so forth for Exhibit E. But then he was going to come back to that. So I don't know if the court would prefer he now cross Dr. Tabaka or I do my cross of Ms. Tabaka.
I prefer we stay in order. So if he was concluded with the plaintiff, then we would go into your cross of the plaintiff. Okay. Mr. Schaefer, so you are concluded with your client?
Your Honor, I guess my client's been called for cross already, and then Mr. Tabaka went on, and Ms. Lane is correct that his cross was delayed until the notes came through. I think I completed with my client, but my notes indicate that we were at a point of crossing Mr. Tabaka, but whatever Your Honor believes is accurate is fine with me.
Well, I have my notes that I said still on direct with plaintiff, but if you concluded, then Ms. Elaine can engage in cross-examination of your client.
Okay, that's fine, Your
Honor. Okay. Ms. Tabaka, you are still under oath in this matter. You understand that?
Yes, sir.
Okay, thank you. Ms. Elaine, we can proceed with your cross-examination.
Yes, Your Honor. Actually, I should have brought up a housekeeping issue to you briefly. As you may remember, we had a motion to compel the county, who was overdue on some discovery, to us. And we did ultimately, after your ruling that they produced that, receive the documents that we requested. So I would just ask permission. There's not a lot to cover with those documents, but that we're able to do that today with Ms. Tabaka because those records were not available before.
You can go into whatever you want with your cross. I'm not going to dictate what you do.
Thank you, Your Honor. I appreciate that. Ms. Tabaka, you indicated in your testimony that Dr. Tabaka was not asking you to exercise parenting time while you were working. Do you recall that testimony or something similar?
Can you please repeat the question? Because
sure.
Go ahead.
Is it your testimony that Dr. Tabaka was not asking you to exercise parenting time while you were working? He was not making that request of you.
Oh, I never said that he did not make that request.
How many times do you think he made that request of you?
At least 5 to 10 times, possibly, over the course of this litigation.
All right. And would you be surprised to know it was more like 20 times?
I wouldn't be surprised. The number of emails were so vast.
You never responded when he made those 20 plus requests to you for parenting time while you were working. You never responded to him anything along the lines of, that's not what the order says, correct?
Your Honor, I'm going to object to the general questions. We have talked about months and months and various times, so I don't know which moment she is talking about. I think it ought to be specific. Otherwise, I'm not sure how my client can understand which matter she's talking about. Well,
if she doesn't understand, she can say she doesn't understand, but I think Ms. Elaine was asking a generalized question.
Okay, could you please repeat for me, Ms. Lane?
Of course. On the times that Dr. Tabaka asked you for parenting time while you were working, you never responded to him that that's not what the order says, correct?
I don't recall. What I recall for the most part in most of my communications through the OFW Wizard, when he would email me, I would let him know that I received his message, that I had forwarded it to my attorney, because generally it was written in a rather harassing way, and I did not want to instigate anything. And if there was anything else to add, like I was going to be home with the children, that would have been added.
Okay, so my question to you is, and I believe you said no, but I just want to have clarification on that point, that you never responded to Dr. Tabaka indicating that you wouldn't honor his request for parenting time during your work hours because that's not what the order says.
No, I never made a comment or statement such as the one you just provided.
And you didn't do that because you knew that he had the right to that parenting time under the order, correct?
No, ma'am, I don't want to say something that's insulting, but from my experience with my ex and his personality type, the best answer that can be given to him is to just acknowledge that his message is received out of respect and communication, and let it be there. Because
And
go
sorry.
ahead. You go ahead.
And you described his messages to you on this point of asking for parenting time during your working hours as harassing, correct?
Yes, it's harassing to me.
Okay.
Yes.
And we're going to take a look at some of the messages where he asked for his parenting time during your work hours. And the first one, I believe, was admitted last time, actually, 6/28. Yes, this was already been admitted as Exhibit D, where he says in paragraph 2, I think we went over this last time, but do you consider that harassing, that paragraph 2?
Is that message 37 you have up there?
Yes. Yes, with an almost 6-year history of taking care of the kids while you are working and with it written into our custody agreement, please consider this advisement in advance that I have plans / look forward to continuing to exercise my parenting time while you are working. In addition to various camps and activities, we have everything from Prodigy to Spanish to GRASP set up this summer to prevent summer slide, especially after these past COVID remote learning school years, which according to several local teachers have wreaked havoc in all of the kids' education. Was that harassing?
Thank you, Ms. Lane. That was not the entire message, though. It starts.
Okay, I don't need to read the entire message, just so that you know. I'm just pointing you to the part that he's asking for his parenting time during your working hours. Is that harassing?
Yes, ma'am.
Okay.
It is.
Okay.
It's harassing.
I'll point your attention now to message 149. And Your Honor, what I've done for efficiency is submitted their entire Our Family Wizard communication as one exhibit so that we don't have 30 separate email exhibits. I provided that to Mr. Schaefer, and I'll identify the messages of note as we go along by the message number and page.
Okay, Ms. Lane, what was the last message? Just so I didn't get the number.
Yes, the last message had already been admitted as.
I know.
Oh, sorry.
I'm just looking for the number.
The number, yes, sir. It is 37.
Okay, thank you.
You're welcome. All right, so I would move to admit the entire Our Family Wizard communication, which consists of 415 pages, as Exhibit H.
I don't think the proper foundation is for 400 pages of this, so I can't agree to that. They have to be identified as to relevance. They have to be identified as to what's going on. The volume of this is enormous, and do I have in memory what 400 pages are? No, I don't. So I think if she wants to introduce any or all of these, I think it has to be foundation as to each one.
Ms. Lane, what's your reply?
I mean, Your Honor, there are clearly Our Family Wizard messages between the two parties. Nothing else exists in them. The reason I'm offering them as a whole is to avoid a lot of back and forth about whether something is the whole message or only part of a message or response to a message. It's just all there. I don't intend for the court to read the whole 400 pages, and that's why I'm going to go through the ones that I believe are relevant to the issues at hand and identify them as such. And it's a time-saving measure over having to admit about 30 separate emails.
Well, what the court's going to do is I will admit the Exhibit H with the understanding that we are going to highlight the relevant portions of that. And so the court will do that, obviously, to save simply on time to get these matters admitted without going through and authenticating 415 pages, with the idea that you're going to specifically identify and address those relevant pages.
Thank you, Your Honor. I'll direct you now to message 149, Ms. Tabaka. In this message from Chris to you, he says, on a different topic, and to repeat my prior Our Family Wizard messages, I would like the kids at any and all times that you are working. Is that harassing?
Me, ma'am, yes, given the nature of the abuse in this relationship, just as the last message, it is,
Just a yes or no, and we'll get through this a lot faster. That's harassing.
yes, ma'am.
Message 181. Paragraph 6. As per our 2015 parenting time court order, I've clearly and repeatedly stated in our family wizard that I would like to exercise my court ordered parenting time while you are working. Subpoenaed work records clearly show that this order has not been followed. My attorney is set to file for enforcement. Is that harassing?
Your Honor, may I please elaborate with more than yes?
Just a second, could we scroll down because I can't see the whole exhibit?
What part are you missing?
Well, I can see from 5 down. The rest of it is not on the screen. Okay, this is 526. Okay, do we have a moment to read this? There are apparently 8 paragraphs on this.
Okay, take your time to review it, Mr. Schaefer.
Good. Be fine.
So, Your Honor, may I please answer with more than a yes or no?
No, you can answer the question, ma'am.
Okay, no, sir.
No, this is not harassing? Or
Sorry,
yes, it is.
I apologize. Yes, in context it is, ma'am.
This is harassing. Okay. And well, in context of the other paragraphs that's harassing, or in context of other things?
That entire email and the nature of most emails have many elements of harassment, always generally bullet pointed as point 1, point 2, point 3,
Okay.
point 4, 5.
So you find it that he's numbering the issues as harassing, or do you find the content of it harassing, or both?
Years of experience of communication for secret penman to his parents. He does this to harass. Yes.
Okay. So just in general, his communications about your children are harassing, and we're looking at one of those harassing emails.
Not all emails regarding my children are harassing, ma'am.
But this one is.
It is.
Okay.
Yes.
189, he writes you, this email is to advise you in advance, court orders exact language that I intend to exercise my parenting tomorrow while you are at work. This is clearly spelled out under the parenting time section. Kindly let me know when you or we finish with work so I can plan to meet you at the Denny's. And you say back to him, unfortunately, tomorrow's my day with the children and I will be spending the day with my children. So first of all, is his message harassing?
Yes, ma'am.
And then your message back is an example of a time where you did not dispute his request by saying that's not what the court order says, right? You just said, I'm not working or I'll be spending the day with my children, correct?
Madam, I'm not sure that I referenced the court order. I tried to keep my responses limited.
Okay, you're not sure if you reference the court order or you definitely don't reference the court order.
Well, in this particular email, I did not reference the court order in my response.
Message 194. Chris writes to you, this email is to advise you in advance. I intend to exercise my parenting time tomorrow, June 14th, 2022, if you will be working. You respond, thank you for the communication. However, I will be spending my day with Maddie and Daniel tomorrow. First of all, is his email harassing?
Request regarding a specific day is not harassing. It is a legitimate request.
So he's allowed to ask you about a specific day and that's not harassing, but he can't ask you or remind you that the court order says whenever you're working, he has parenting time. That would be harassing.
Yes, it would be.
And again, you don't respond to him that the court order doesn't allow you to have this time, correct? You just said you'll be spending your day with the children.
Yes, I try to keep my communication with them limited.
Well, you could have a very limited response to say that's not what the court order says to every single one of these, which is actually shorter than what you're responding, correct?
Your Honor, I think this is almost argumentative. It is what it is. She answered the questions. It's not the answer she wants, but I don't think it's argumentative at this point in time.
I will sustain the objection. Please move on.
196. Thank you, Your Honor. Dr. Tabaka writes, as per the court ordered agreement, this email is to advise you in advance. I intend to exercise my time tomorrow if you will be working. And then you say tomorrow you'll be spending your day with the children, correct?
I apologize. Let me see what this is. Okay, and the question again was, do I find this harassing?
I was going to ask that, so you can answer that one.
I'll say no on this one. It's
Message 208. Dr. Tabaka writes again, as per our parenting time agreement, I want to exercise time tomorrow, June 24th. You say tomorrow is my day with Maddie and Daniel, and I will be spending my day with them, correct?
correct.
Message 213. Dr. Tabaka says, as per our parenting time order, this is advance notice that I want to exercise my parenting time with the children tomorrow. And you respond, we have a full day of events, correct?
Yes, ma'am.
Message 215. Essentially the same thing occurs regarding July 2022 parenting time.
I don't have July.
Message 215.
It was okay.
Ma'am, I'm just looking for you to confirm that he asked again and you said you were picking up the children at 9 a.m.
Well, yes, if we're confirming on what an email says, that is what email says. Yes, ma'am.
Your Honor, I'm going to object to 223. This is beyond the time period of the filing of the petition. The petition was filed on 7/18 of 22, so it goes beyond what the allegations are in the petition.
Okay, Ms. Lane?
Well, Your Honor, as you know, there's been quite a lot of delay in getting this hearing heard, this matter heard. And so far in this hearing, we've gone all the way through November of 2022, November 3rd of 2022. There's already been testimony about all those dates. I have additional information from the county that I was going to present today that takes us through February. And while it is true that the July or whatever date it was petition could not have possibly included future forward time, this is a continuing event that goes through as we sit here today. And for economy and the sake of saving attorney fees for all parties and saving important judicial time, I would ask that this court did consider all ongoing violations that we have evidence of through, right now we're through about February of this year.
Well, I understand all that, Ms. Lane, and I understand the judicial economy, and obviously this court doesn't want to be back in later to listen to the same thing. But the fact is, Mr. Schaefer does have a right to due process notice of what he has to defend against in this matter. And understandably, it's not in the petition, so the court shouldn't consider it for purposes of the relief at this particular time. Doesn't bar you from subsequently filing or anything of that nature, but let's confine ourselves to what's in the pleadings. You could have filed supplemental pleadings as well, and that wasn't done. So let's confine ourselves to the pleadings.
Your Honor, is it impactful on you at all that this objection was not made when we spent hours going all the way up through November of 2022 in the last hearing?
No, the court will consider what there was not an objection to.
Our Family Wizard messages that we've gone through, and I think you've already acknowledged this. You never responded to Dr. Tabaka's requests for the children during your working hours on any variation of, that's not what the order says. I don't know why you're asking me this. I have no idea what you're talking about, etc.
Correct, ma'am. I try not to have arguments through emails with Dr. Tabaka.
Couldn't you have just shut the whole thing down by saying the first time he ever mentioned that to you, which was the 6/28, 2021, Our Family Wizard? Wouldn't a normal person who didn't believe that he was entitled to what he was asking for just say, you're not entitled to that? That's not what
I'm going to object. This is argumentative. I don't know what a normal person is, and I don't know if it's the proper question. I object to the question.
I will sustain the objection. I guess she could have responded in many ways. She didn't. So let's move on and address what the issue is today.
Okay. Why, Ms. Tabaka, did you take the pains to tell Dr. Tabaka on his requests that you would be with the children rather than just saying, no, you can't have the time?
In my personal opinion, that kind of answer is rude and like retaliatory harassment to answer that way. I had no interest in pushing an angst further. I just wanted the answer known and to be done, not to write a long email about my feelings on the matter, just simple and done.
Well, I'm not talking about your feelings. I'm talking about your beliefs, because you want this court to believe that the provision we have asked the court to find that you violated wasn't operational in the way that we say it was.
Again, Your Honor, this is argumentative. She answered the question. She asked why she answered the way, and she answered it. So it becomes argumentative at this point.
Well, court is going to sustain the objection. Let's move on regardless of what her thoughts are as to the order. The order will stand by itself and we don't need her to interpret it or what she believes to be the interpretation.
Fair enough, Your Honor. Thank you. I have some questions for you, Ms. Tabaka, on the parenting time chart that has been admitted as Exhibit E. And by the way, Your Honor, that was conditionally admitted and us providing the supporting data, which we did. So I would ask that the conditionalness of that admission be removed.
Okay, Mr. Schaefer.
Your Honor, I think I will admit that there has been additional notes provided on May 2. So I need to have the ability to cross-examine on that offer of exhibit before it's entered.
I guess I'm in a quandary, Mr. Schaefer, as understand you wanting to cross-examine, but the fact is when somebody introduces an exhibit, you don't get to cross-examine when they're introducing the exhibit. I mean, you have an objection or you don't have an objection.
Well, my understanding, it was conditionally accepted based on the production of the notes from which Mr. Tabaka indicated that he was gleaning these things. So that's the condition that it was entered. And I have them now. And if I had them then, I would have been able to cross-examine as to the accuracy of the exhibit.
Yeah, court doesn't believe that goes to the admissibility of it. Obviously, may go to the weight. And again, you have a right to cross-examine, but I'm going to admit the exhibit.
Thank you. All right, looking at Exhibit E, Ms. Tabaka, I have some notes as you went through this on your direct examination by your counsel, and I believe there were some dates that were skipped, probably unintentionally, so I just want to go back and have a clarification there. I believe one of the dates skipped was Wednesday, November 10th, 2021. And it's this one. Dr. Tabaka is claiming 8 hours of missed time. You worked 8 hours that day, and that was time that Dr. Tabaka otherwise should have had the children. Do you agree or disagree with that?
Your Honor, I object to the testimony, and it may or may not be what the indication is, but I object to the question as being a multifaceted question with a lot of presumptions that may or may not be accurate.
Well, if the facts upon which she is questioning are not accurate, you have a right to object to that. I don't think you can give a nebulous objection, say, well, I don't know if it's going to, again, pertain to that or whatever. So if you have a specific objection, make it. If not, then we'll proceed.
Okay, I object that the premise is not accurate in evidence.
Okay, Ms. Elaine?
I'll try to fix it, Your Honor. Ms. Tabaka, did you work on November 10th, 2021 for 8 hours?
Yes, I worked at home with my children present.
So you worked.
Yes, the defendant didn't give me notice for that date.
Ma'am, just answer the question that I asked, please, so that we can move along. How about Monday, January 21st of 2022? Your timesheets indicate that you worked 6.5 hours that day. Do you dispute your timesheet in that regard?
If the question is, am I going to dispute my timesheet? Absolutely not.
Actually, I'm sorry, I have the wrong day on that. I meant to direct you to 1/24 of 22. Your timesheet indicates that you worked 7.5 hours. Do you dispute that?
I'm not going to dispute time that I work now.
Okay, thank you. Isn't it true, Ms. Tabaka, that you took great pains to find ways to not work during your parenting time so as to prevent Dr. Tabaka from having the children?
Your Honor, I'm going to object to the relevance of that question.
Okay. Ms. Elaine, how is that relevant?
Well, I have some evidence that's going to support that she did that, which goes to our claim that she knew she was violating the order, which this refutes her claim that the order wasn't what we say it was.
Well, if she was not working, then it wouldn't be applicable. It wouldn't be a violation. It's only he was to have the parenting time if she was working. So right. I don't believe it's relevant to these proceedings.
But Your Honor, she is saying that she didn't have to abide by that provision, or that it didn't say what we say it does say. And there is suggestion.
Quite frankly, I don't care what she says about what it is. I will interpret the order as the court interprets it. It's a matter of was she working, was she not working?
Okay. Your Honor, I have no further questions.
Okay. Mr. Schaefer, any redirect?
Okay, thank you, Your Honor. I guess you were asked under Exhibit E a number of dates. I go 1/24 of 22. Was there proper request for parenting time by Mr. Tabaka?
I'm sorry. There was no notice given. So,
No notice given in that regard. As to 1/24, you were asked about 11/10 of 21. Could the screen be? I guess that is up there. 11/21. Was proper notice given to you at that time for parenting time by Dr. Tabaka?
11/21.
You'll have to speak up, ma'am. I didn't hear you.
11/10 of 21.
10 of 2021. No, sir. He did not give any advance notice to have the children that day.
Okay. You were asked about, one was, why did you respond as tersely or shortly as you did? And was there difficulty communicating with Mr. Tabaka in relation to these issues?
Objection leading.
I asked you, was there difficulty in communicating? That's not a leading question. It's a yes or no.
Go ahead. I'll overrule the objection.
Thank you, Your Honor. Yes, sir.
And what difficulty was there?
With the history of abuse and the way that Chris communicates. Answering.
Your Honor, I would object to this line of questioning regarding difficulty in communication that she claims. As Your Honor has already ruled, you will look at the provision and whether it was violated or not, and her reasons for how she communicated to him would be irrelevant in that regard.
It's follow up on her question, Your Honor.
Excuse me?
She asked the question, why did you respond the way you responded? I'm following up on that.
Well, let's move on. That's not going to be determinative in this particular case. It's, as I stated, it's whether, was there a violation? Was there a request? And was she working in a violation or not? Not as to how they communicate.
Okay. In relation to the times of their Exhibit E, we had to put in responses there too that have been admitted into evidence. Is that not true?
Sure.
And have you addressed those times that were asked? Is that correct?
Yes.
Sure. No further questions, Your Honor.
Okay. Any recross, Ms. Elaine?
No, Your Honor.
Okay. Thank you. Mr. Schaefer, at this time, do you wish to engage in your cross-examination of the defendant?
Yes.
Okay. Mr. Tabaka, you're going to be questioned at this time in your cross-examination. You're still under oath. You understand that, sir?
Yes, sir.
Okay, thank you.
Mr. Tabaka, there were numerous times that you put on your Exhibit E of claiming time that you were entitled to make up. And they included certain times when there was COVID involved with the family and the kids. Was there not?
Mr. Schaefer, if you could, you're really faint, so
okay.
In and out, so if you could maybe get closer to your speaker or mic, then that would help.
Okay, very good. Thank you, Your Honor.
That's good. We can hear you well now.
Okay, very good. You had listed on your Exhibit E numerous times that you were claiming that you were denied parenting time, and they included at least a time when you and your ex-wife, the mother of the children, had agreed to vacation times. Do you recall that on the following dates of August 2/21, August 3/21, August 4/21, August 5/21, August 6/21? Do you recall agreeing to vacation dates for my client on those dates?
Yes, sir.
But you're claiming time that you should be make up in the amount of 28 hours during that time period, are you not?
Yeah, after hearing the testimony from Alexis, I went back and looked at the records, and I agree those should be removed.
Oh, okay. So you are saying that 28 hours request should be removed.
I don't know if it's 28 hours. I know the dates are between August 2nd and August 6th. We had agreed to vacation during that time.
Your
Yes.
Exhibit E, I am representing to the court. If you add those up for those dates, there's 28 hours that you're requesting that you are indicating you have
If it
quorum with
saves time,
that.
that's correct. It's 28.
Okay. Then yes.
Okay. On 11/5 of 21, there was COVID and no school, and you were claiming time for that. Is that accurate?
That is correct.
And are you suggesting that if there is a COVID problem and there's no school, that you should have gotten 8 hours of credit on that particular day?
Yes, sir. Alexis was working. We all had COVID. I had COVID. Mary Beth had COVID. Kyle had COVID. Kids had COVID. Everybody had COVID. So,
Well, if you look at the chart, she was home with the children on that day. So you are suggesting that even though there's COVID out there, that there should be travel and should not stay home with the children? Is that your position?
Objection to facts, not an evidence or misstatement of the evidence. The question is whether she worked, not whether she worked at home. So the choice.
Well, the court is interested in whether she was working at home or not working. She's working at the office, so I will allow the question.
If the children are home because of COVID, do you think it is appropriate that you would be able to have the children with you rather than staying at their home?
yes, because she was working and couldn't take care of the children while she's working, whereas I wasn't working and could take care of the kids during that time. So, yes.
Well, let me follow up on that. If she were home with the children, working or not, then that would be a relief from that concern of your standpoint, would it not?
If she's working, how is she able to take care of the kids?
Okay. If in fact she were home, not working because the kids had COVID, that would be appropriate reason not for you to have the children, correct?
If she wasn't working according to court order, yes, she would.
Okay. On 9/3/1, you are claiming some time, and the kids were home, and the chart would indicate from Ms. Tabaka she was home with the children. Would that?
We didn't hear the last of that, Mr. Schaefer.
Okay, and the chart submitted by Ms. Tabaka would indicate that she was home with the children. Is that if she's home with the children and working different hours than when she's home with the children, would that be an appropriate reason that you don't get the children under your interpretation of the order?
I don't understand your question. She worked between 9 and 4 that day, which is the hours that I would have the kids.
If she worked different hours that day, was home taking care of the kids because of no children, would that be an appropriate amount, a reason for not having the children go with you?
Objection to this hypothetical. The hours are what they are from her timesheets. So I don't know why he would be asked if they were something different. Would that have excused the violation?
There's been testimony in this record already by my client that she had flexible and she would work times that were not the 8 to 5, that she'd work early, she'd work late, and that would dovetail into this particular matter.
Your Honor, she also testified she was truthful on her timesheets, stands by her timesheets, and there are myriad examples on her timesheets where she records different hours, like working 11 p.m. to 4 a.m.
This is argumentative, Your Honor. It's what the proofs are into the evidence.
Okay, well, let's move on. I mean, I'm interested, but I don't want to speculate as to what the hours might have been. We can have testimony about that.
There were times that the schools were closed because of storms and bad roads, specifically on 1/21/20, 1/24, 2/2, 2/4 of 22. And you are complaining that you did not get the children on those days. Is that a legitimate reason why you should not have gotten the children?
I am not sure what days you're talking about, Mr. Schaefer.
I gave the dates.
Can you just take them one at a time, please?
1/21 of 22, you are claiming 6.5 hours. And that was a snow day for the children. Do you recall that?
I don't recall it, but I see what we have written down here. I don't recall it memory-wise.
And 1/24, there was a snow day also, and you're claiming 2.5 hours. Is that correct?
That is correct.
And on 2/2 of 22, you are claiming 8 hours, and that was also a snow day. Was it not true?
I don't know if that was a snow day or not. I don't have that here.
On 2/24 was a snow day also, was it not? And you're claiming 6 hours.
I don't have any record of 2/24, Mr. Schaefer.
On 2/18/22, you're claiming 6 hours, and that was also a snow day, was it not?
I don't know if that was a snow day or not. I know she worked for 6 hours that day, and I claimed 6 hours.
Okay. And did you make request for the children on 2/18/22?
I made requests to have the children anytime that she was working, as pursuant to the court order and the 6 years of history that we had prior. So I would say yes.
In relation to 2/18/22, when did you make request to have the children on that day?
I think that was covered under the statement made on 6/28/21, that with an almost 6-year history of taking care of the kids while you're working and with it written into our custody agreement, please consider this advisement in
Okay.
advance.
Okay,
Already
what
gone
date?
I'm
What
sorry,
date?
could you, objection, he cut my client off when he was trying to answer the question.
Okay.
He's not responsive. I asked what date did he give notice, and then he's rambling on.
I think he was trying to answer. Mr. Tabaka tried to answer that as to what date as it relates to the 2/18/22.
Okay, Your Honor. On 6/28/21, we've already gone over this in testimony. With an almost 6-year history of taking care of the kids while you're working and with it written into our custody agreement, please consider this an advisement in advance that I have plans, look forward to continue to exercise my parenting time while you are working. In addition to various camps and activities, we have everything from Prodigy to Spanish to grass set up this summer to prevent summer slide, and so on and so forth. We already went through this a little bit earlier.
So your answer is 6/28/21.
That's why I informed her that I would like to have the kids anytime she's working. Correct, sir?
In relation to 2/18/22, was there anything a day before, the day of, the week before that you gave notice to her?
The statement in the court order is in advance. 6/28/21 is in advance.
My question is there a date close to 2/18/22 where you gave her notice?
I gave her notice in advance.
Your Honor, could he answer the question, please?
Mr. Tabaka, could you? He's asking for whether any other notice close in date to the 2/18/22.
Not a day or two in front or behind that one. No.
Okay, the same question as to 2/4/22. When did you give notice to one of the children on that particular day?
Again, going back to the 6/28/21 advance notice for anytime she's working.
And so anything close to 2/4/22, there was no notice. Is that correct?
What's your definition of close?
What's the closest time that you made a request to have the children on 2/4/22?
Asked and answered.
I'm not sure. It is.
He answered.
If the answer is June, fine. I just need to know if that's the last time.
Mr. Schaefer, that he did answer, and that's what it was. He referred back to the 6/28/21 request.
Okay, very good. On 2/2/22, did you give advance notice of you want the children on that particular day?
I did. Again, that was on 6/28/21.
On 1/21/22, did you give advance notice for that date?
Again, same answer. I gave advance notice on 6/28/21.
On 1/24/22, did you give advance notice for that date?
Again, I gave advance notice on 6/28/21.
And what was your notice as to your plans on that date with the children?
Objection. We had a ruling from the court during the last hearing that the court was not interpreting that piece of the provision as requiring Dr. Tabaka to give specific plans.
Mr. Schaefer, what's your response?
The order is, as Your Honor indicated, as it reads, as advance notice and plans. So I'm asking what plans he had given.
Well, the court, as I stated last time, the court interpreted that as being the plans to take the kids, not an itinerary of what he was going to do when he had the kids with him. So I'm going to sustain the objection.
Okay, thank you. On 12/20, on these dates, did you show up at the place of exchange to pick up the children?
Objection. The question is vague.
Well, then I'll be very specific. On 12/22/21, did you show up either at the Denny's or did you show up at the preschool place, which is the place of exchange?
I don't recall. I don't know if there are any other OFW messages going on at that time. If she said she had the kids, I don't know. That was
Let
almost,
me ask you. Okay, excuse me.
that was almost a year
relation-
ago. I just don't remember.
And so on the dates that you have indicated of 12/27/21, 12/28/21, you are indicating that do you recall of showing up at the exchange location for the children?
Objection. There is no 12/27/21 on the spreadsheet.
There is, Your Honor. At least on the original one, there was 12/27, 12/28/21.
I see a 12/22. I'm not seeing a 12/27.
It's on a 12/27.
Well, it sounds like Mr. Schaefer, we can agree that there was no 1227. They're not now at this point stating that they're not disputing that.
On 1/21/22, did you show up at the exchange point to receive the children?
Your Honor, I would object to this line of questioning as well as to relevance, how it's relevant whether he showed up to pick up.
Well, the
children.
relevance, Your Honor, is if in fact he requested the children, he has an obligation of showing up at the exchange point to get the children.
I will overrule the objection. It is relevant in this matter. If he, even if he requested and didn't show, then that's relevant. So go ahead.
On 1/21/22, did you show up at the exchange point?
I assume not, but I have absolutely I had no idea when she was working until the subpoenas were submitted, so it'd be impossible to know whether
So
or
the
not.
answer is no, you didn't show up.
Objection, Your Honor. My client was cut off trying to answer the question.
The answer was a yes or no. Did you show up at the point on that particular day?
I would assume not, but I don't know. I
Okay.
remember all that far back.
Okay, on 1/24/22, did you show up for to receive the children at the exchange point?
Yes, I picked them up at 11:30 that day.
Okay, let's talk about that a little bit. You picked them up at 11:30. And so you are quarreling about 2.5 hours in that day, is that correct?
That is correct.
And why did you pick them up at 11:30?
Because if Alexis isn't working, then that would be the time I would pick them up. However, that morning she had worked, which I had no way of knowing. So I showed up at 11:30, which is what the court order states.
So how did you figure 2.5 hours?
Between 8 o'clock or 8:30 or 8:20 and 10:50.
And how did you come up with the dates that you figured your time?
How did I come up with the?
There's no time specified in the orders. Is that true? In the 2015 order?
There are times specified in the order for Mondays. It's 11:30. Drop off is at 11:30 on Mondays. If she isn't working, if she is working, then it's before she goes to work or when she goes to work or whatever, and I get the kids. That's
Okay,
how I've
well,
done for 6 years.
can you point out to me in the order where it says that? There are times in relation to the weeks, but the asterisk amount on both of these seem to say that you're entitled to some time in the morning or the afternoon, depending on which child it is. Are you suggesting there are time frames in that?
Can you show him the order, please, so that he can review it?
You see the asterisk points of the order at this time, Mr. Tabaka?
Yes. You're talking about the highlighted asterisk where it says asterisk note?
Yes.
Yes.
Well, that's the portion that you are relying on, is it not, for asking for time when Ms. Tabaka is not working? Is that not true?
Seems to me that looks like it's specifically talking about Fridays.
I understand that, but if in fact you are entitled, if you're in fact entitled to time with the children when my client is working and you make the request and so forth, is that not the section of the order you're referring to?
I believe so, yes.
Okay, and I'll read the first part. It says defendant may take the children for afternoon parenting time and the minor child for morning parenting time, and both children on Fridays, subject to provisions and during such time as plaintiff is working, so long as plaintiff is advised of defendant's plans in advance. Is that a correct reading of what the order says in that part?
That is a correct reading of that portion of it, yes.
Okay, all right. And there are no times in that. It's not 8:30, it's not 8:15, it's not 11 o'clock. Is that correct?
It's stating Monday in that section, no, but go back to
Okay,
the later section.
okay, all right, fine. That's my question.
Yeah.
And the asterisk point under week 2 on the lower part of what is shown, that is the same language that I read from above. Is that correct?
Yes.
And that contains no times of 8:30, 8:45, or anything else. Is that correct?
States when the plaintiff is working. It does not have specific times.
Okay, very good. Thank you. On 3:30 of 22 on Exhibit E, you're claiming 4.5 hours. And was that not a time when the kids were having piano lessons?
I don't know if the kids had piano lessons that day. That's I don't know which child had piano lessons that day. Their schedule's been all over the map in terms of piano, so I don't know.
Well, you agree that if in fact the kids had extracurricular activities, then you would not be entitled to make up during that time whether your Mr. Baca was working or not, correct?
I would argue that if Ms. Tabaka was working, that I have the court order says that I would have parenting time with the kids, including taking them to their extracurricular activities, which I do, including piano. I was not given that option because even with Ms. Tabaka working, somebody else was taking the kids to piano. This doesn't, I would obviously have taken them to piano. I do that all the time.
Well, so you had some entries here also of a half hour, an hour. Are you asking for time makeup because of the time of delivery of the child and school?
Could you be specific, sir?
I will, just a second.
Okay.
All right, how about Friday, June 17th of 22? You're asking for 1/2 hour from 9 to 9:30 in relation to Daniel's sleep appointment. Can you explain that to me, why you think you're entitled to a makeup of a half hour there?
In retrospect, sir, I would have asked for an hour and a half between 8 and 9:30 because your client was working during that time period.
So your position is that, where was my client living on that particular date based on your information?
Objection, Your Honor. Relevance, if she was working.
Relevance as to the reasonableness of the request and the validity of the request of makeup.
Your Honor, again, the order is clear. It doesn't say if it's short, he doesn't get the time.
Okay. Well,
I'm trying to figure out what the time would be.
okay, go ahead. You can answer it, sir.
Where was Mr. Baca living at that time, as you understood?
On Beckley Road in Battle Creek.
Okay, and what's the distance between Beckley Road and Denny's?
Beckley Road and Denny's, I don't know, 10, 11, 12 minutes, depending on traffic.
Okay. And you asked for a half hour on 7/11 of 22. Is that the same reason of the time to deliver the child to some place? And can you explain why you're entitled to one half hour at that date, please?
Yeah, could you ask the question again? I lost track.
What is your position as to why you're entitled to a half hour makeup?
Again, reading the court order because she was working during that time. I just calculated that one from 9 to 9:30. My kids wake up here at 7:30. So, oops, just missed it. So I asked for a half hour time.
So at a half hour time, did you go to Denny's at that time or the preschool for the pickup?
I'm sorry, I lost video here.
Did you hear the question?
I'm hearing the question. My video went down. Could you ask it again, please?
Sure. Were you at the pickup point on 7/11 of 22?
Objection, Your Honor. If she is not telling him that she's actually working, he has no way of knowing that it would have been his time. Thus, it is irrelevant whether he went to pick up children that he didn't know he could pick up.
I don't think it's irrelevant. It's certainly relevant, Your Honor.
I'll overrule the objection, allow it. You can address that on redirect.
Thank you, Your Honor.
Did you go to the pickup on 7/11 22?
No.
Did you go to the pickup on 7/1 of 22?
Actually, let me rephrase. 7/11 of 22?
7/1 of 22.
No, your prior question, sir. Was it on 7/11 of 22?
Prior question was 7/11.
Yes, I went to the pickup time at 11:30 that day. That was a day I picked the kids up at 11:30.
And you got the kids at 11:30, correct?
On 7/11, I believe so, yes.
And prior thereto, did you go to the pickup to represent the 1/2 hour you're claiming?
I had no way of knowing, of course, so no.
No. And 7/1 of 22, did you go to the pickup?
I think there might have been some OFW communications regarding that one. I'd have to go back and look. I didn't go to the pickup.
Okay, that was my question. Did you go to the pickup? The answer is no.
I don't believe so, no. I think there were communications about that day in OFW.
Okay, I don't have a question, thanks. 6/3 of 22, did you go to the pickup?
I don't know.
Okay, on 5/31,
I wouldn't, Mr. Schaefer, if on days where she's working in the afternoons,
okay, my question is, did you go to either
the
Denny's?
pickup place
or
would be, the pickup place would be the school on that day.
Okay.
Because the kids, if she's at work, then she can't get the kids, so I get the kids and I would meet her at the pickup place after. So yes, I got those at the pickup place.
Well, you agree that the order does not say that. The order says either the preschool location or Denny's, correct?
Preschool being they are now at school, so I was at the school location.
That's not what the order says, does it, Mr. Tabaka?
No, but the kids are no longer in preschool, so
Okay,
it's still school, but
And that's subject to argument. So you did not go to the preschool or Denny's on 5/11, is that correct?
do not go to the preschool or Denny's on 5/11, no.
On 4/18 of 22, did you go to the preschool or Denny's as the pickup?
Your Honor, again, for efficiency in this hearing, we will stipulate that when the children were not in preschool during the times at issue, Dr. Tabaka did not go to the preschool to pick them up. I would also
That's
ask,
fine. I accept the stipulation, Your Honor.
Okay,
I would also ask for a ruling on this point again, that if Dr. Tabaka has no way of knowing that he had the right to have the children, then he wouldn't have gone to the pickup. So he didn't go to the pickup on any of the times he's claiming that he's now owed time that he's later discovered she was working.
Yeah, this is argumentative, Your Honor, and there's lots of arguments against that. So
well, we can argue that. I would state that he had talked about going to different exchange points on different dates. So the court will accept it for what it's worth.
are you asking for any time of makeup during any of the extracurricular activities that the kids have?
I consider that my parenting time where I would take the kids to the extracurricular activities, so yes.
And how about the art events with your parents? Were you going to take them to those extracurricular activities?
Those are not my parents, Mr. Schaefer. I have a mother who lives in Flint. They're my biological parents, but I have nothing to do with them. So, no.
So the answer would be no, you would not intend to be traveling on those extracurricular activities when they had events with their grandparents. Is that true?
Your Honor, that assumes facts, not an evidence that the children had events with their grandparents.
I believe my client testified to that a number of times. It's on her chart, and I will revisit that, but that's certainly what the situation is.
Your Honor, those were events that she just planned and then worked.
I understand. I understand. So I think it's a legitimate question. Go ahead.
So I understand, Mr. Tabaka, if there were extracurricular activities with your biological parents, you would not have intended to deliver the children to those events. Is that correct?
I had no way of knowing that there were events with my biological parents.
That wasn't the question. If there
They're also
were,
not-
if there were extracurriculars with your biological parents, would you have intended to deliver the children to those events?
Your Honor, relevance.
He is claiming time for the travel time to the other events, Your Honor. All I am is trying to find out if he's claiming this or if he is not.
Your Honor, he specifies what he's claiming. He's claiming the time that he should have had the children while she worked, regardless of what other plans she made with them.
Yeah. Let's move on. I guess I'd say I'm not going to interpret the order differently if she had planned events or didn't have planned events. It's whether she was working.
I believe Your Honor made a ruling earlier in relation to extracurricular activities that they would not be taken into consideration. That's my notes indicate of your ruling.
I don't recall that ruling. I don't believe there was that ruling.
I don't recall that either, Mr. Schaefer, so you'll have to highlight that to me.
Well, okay, just a moment. Mr. Tabaka, I guess let's jump to the chase here. This is you are asking for some makeup time hours, and you pled 146 hours in your pleadings. You have at least agreed that there is at least 28 hours that was inappropriately put on your chart. Is that accurate?
Objection. There are two parts to that question. I would ask that counsel break that down.
I didn't think there was.
And I think it's appropriate. Go ahead.
Are you able to answer that question? Do you understand the question?
Could you repeat it again, please?
You pled that you had 146 hours of makeup that you were asking for. Is that correct?
I think it was 146. I don't know. I believe it was somewhere around there. If you're talking about the original, if you're talking about through July, it's a living document, so it's like 250 right now. I don't know what the exact numbers were that you're talking about.
Okay, well, let's look at it.
Okay.
You filed pleadings in this matter that we are answering, and you had requested 146, and I think a fraction of makeup hours. Do you recall doing that?
The document I have in front of me is 211.25 through November 3rd.
You're gonna have to listen to my question. You signed a document on 7/8/22 and was signed by your attorney at that time on that same day, and that was filed, and that's the motion that we're here today on, the motion for order to show cause and request for makeup time. You recall signing that?
I do recall signing that.
All right. On paragraph 6, you said plaintiff has withheld the children from defendant while she is at work for a total of 147.5 hours up to February 18th of 22. Exhibit A. Do you recall that?
Natalie could confirm that that's the hours, then I just don't know the hours offhand, Mr. Schaefer.
Did you sign a document with that language in it?
To repeat, sir, I don't have the exact hours in front of me, so I'm not going to stipulate something that I can't see.
That is not my question. My question is, did you sign that petition with that allegation in it?
Your Honor, he could show him the document and ask him to confirm it.
Well, it's his document, Your Honor. It's his opinion. That's why we're here.
He doesn't remember it from a year ago, Mr. Schaefer.
Well, that's understandable that he might not recognize that. If you can show him that, Mr. Schaefer, that would help.
Mr. Tabaka, can you see paragraph 6 of
Yes.
that pleading?
Yes.
And when you signed that agreement, that's what you were asking for. Is that correct?
147 and a half hours up through February 18th. Correct, sir.
Okay. Now, if you've agreed, have you not, that there is 28 hours that should be reduced from your pleadings? Is that correct?
If 28 hours was the time for that spring break and summer break, then yes. I don't know what the total of those hours were either at this point.
Well, your attorney stipulated that were 28 hours.
If it was
Correct.
28 hours, then yes, I agree. I just don't remember
Okay.
the exact number.
So is your best position at this point, the 147.5 minus 28 hours you're asking for makeup?
Your Honor, this court said earlier that it would consider anything that wasn't objected to before, and those hours went through the November 3rd, 2022 date.
I'm not sure that was the ruling, but it's a legitimate question. He can answer it yes, no, or indifferent.
I'll take it only because paragraph 6 does state through February 18, 2022. So it's part of the pleadings.
Is that your position, Mr. Tabaka, as to what you're asking for?
Could you repeat the question one more time, please?
Is your position that you're asking for makeup time of 147.5 hours minus 28 hours, whatever that arithmetic is?
Through February 18th of 22, yes.
I have no further questions, Your Honor.
Okay. Ms. Elaine, any redirect?
Dr. Tabaka, the additional dates that were considered and at the last hearing totaled, or the 147.5 plus the additional dates through November 3rd totaled 211 and a quarter hours, correct?
Objection, leading question. It's just her client, Your Honor.
Excuse me?
Leading question, objection. It's her client.
Please rephrase it, Ms. Elaine.
What were the total hours that you requested in your spreadsheet that was admitted as Exhibit E and not objected to last hearing, sir?
The total is 211.25 hours through, I have November 3rd on my spreadsheet here.
All right. And then we're subtracting out the 28 hours that you acknowledged today had been Alexis's spring break, correct?
Correct.
And I know you're good at math, but my math says that's 183.25. Do you agree with that?
Yes. Slow math today.
Dr. Tabaka, when you were asked a series of questions about showing up at the pickup point for the time that you're claiming you were denied, how would you have known to show up at the pickup point?
I would have absolutely no way of knowing. I have no idea when Alexis works. She used to have standard hours for the first 6 years. And then, I mean, she's working at like 1 in the morning, 5 in the morning. I have absolutely no way of knowing when she's working until we subpoena the work hours and then look at them and correlate those with parenting time.
And does that, sorry, go ahead.
With friend of the court, I mean, they only go up to 30 days. So there's no way to appeal through FOC because, I mean, you'd have to get it within 30 days and subpoenas, of course, they take, I mean, a month and a half or whatever it may be. So then you're chasing your tail in terms of trying to figure out when she worked and when to, there's no way to do it.
When you talked in your testimony earlier about showing up for some pickup times, what pickup times were you referring to?
I was referring to pickup times like after school. A lot of times I go over and see the kids before they go. Pickup times such as Mondays at 11:30, like during the summers or when the kids are off. Over there at 11:30, seeing them then or picking them up then.
So in other words, your regular parenting time.
Yes, yeah.
Okay. And what has been the standard pickup routine as far as place? What has been the standard pickup place since the children were no longer in preschool?
It's been the Denny's. I think it's exit 112 in Marshall, right off the highway.
Are there any other places that you would routinely pick up the children?
Other than picking them up from school.
Outside.
No, I mean, in terms of when Alexis and I do parenting exchange, that always takes place at the Denny's. There've been some exceptions in the past. If I'm in Battle Creek or if she was around or we were running late or something, we might work something out through before OFW, it'd be through text. After OFW, it's through OFW, letting the other know that we're going to be late. But other than that, it's Denny's.
When you were routinely exercising parenting time during the periods when Alexis was working prior to summer of 2021, where did you get the children after school?
I'd always get the children after school from school. I mean, I walked them to school every day. I picked them up from school every day. Did that for 6 years. So the children had a routine, knew what to expect. Alexis was working, I think 9 to 5, might have been 8 to 4, depending on which job she was in at that time. When she was done with work, she'd come to Denny's. I'd take the kids up there and meet her, and we do the parenting exchange there. Before school, she'd drop them off at typically Denny's at 7:45, 8 o'clock. This is when both kids were at the elementary school. She'd drop them off there. We'd meet at Denny's. I'd get the kids, get them together, and walk them to school. So that was our routine for 6 years.
And when you calculated the time after you received work records that showed when Ms. Tabaka was working, and you calculated the time that you had missed, Mr. Schaefer was pointing to some times where there was a half hour or an hour in the morning. How did you, well, let me show you an example. I think that might be easier for my question. All right, so right here on the Friday, 6/17/22, it actually shows that Ms. Tabaka worked from 5:30 a.m. to 9:30 a.m. Under the literal language of the order, would you actually have been entitled to time from 5:30 a.m. on?
Your Honor, I guess I'm going to object to have him interpret the order, Your Honor.
Your Honor, his interpretation of the order is clear. The court will interpret it as it wishes, but his is clear.
Absolutely. So that's an improper question.
I don't need him to interpret. He can just state the facts.
So, Dr. Tabaka, you were entitled to time from 5:30 a.m. on, yes?
Leading question, Your Honor. Her witness.
How much time were you entitled to that day?
4 hours.
And why did you only elect to put 0.5?
Because I'm trying to be reasonable, compromise, work out a solution to this. And so I'm going to put 0.5 for 9 to 9:30. As I stated to Mr. Schaefer earlier, I should have probably done at least 8 to 9:30 and put an hour and a half in there. The literal interpretation is 4 hours for that. Yeah.
Did you generally choose, when you were calculating hours missed, did you generally choose the same starting time for every morning?
Yes, I tried to go from 8 to 4 or 9 to 5, depending on what job she was in. So I tried to keep it consistent across that. Rather than, again, I probably should have done a literal interpretation, but yeah.
And under the literal interpretation, were you also entitled, in your view, to time where she was working, let's say, all night long in the middle of the night?
The order is pretty clear. If you're working, or if she was working, then I get parenting time. That's how the order was set up. That's how we arranged it. So in the literal sense, yes.
Okay, I guess I'm going to object. I'm not sure who we arranged whatever. I think it's an improper question for him to interpret that and to deal with something that is not in the evidence. We takes two agreements, and that's not what the testimony is.
Your Honor, he's objecting to the answer, which is an improper objection.
Well, let's move on. Court will interpret the orders, and we don't need the parties to do that.
Dr. Tabaka, why didn't you ask for the time that Alexis worked during the middle of the night?
Again, trying to be reasonable, compromise. I don't know how you work from 1 in the morning till 3 in the morning or 5:30 in the morning till 7:30 in the morning. I mean, I don't know how you correlate that with the court order in terms of the interpretation. So I tried to take regular work hours, which is what we had historically done, and extrapolate the makeup time from that.
When you testified earlier that you would routinely take the children to their extracurricular activities, such as piano, give the court an idea of what that schedule would look like. So when would you pick them up? When would you take them to piano, and so forth?
I can give you an example right now. I mean, Maddie's in tennis. In order for her to be in tennis, she had to rearrange her piano schedule. So we set it up for 3:30 on Wednesdays. Alexis's mom has been taking Maddie from tennis to piano. I take her on alternate weeks.
I don't mean to interrupt, but before this issue began to arise in June 2021, were you taking the children to extracurricular activities?
Constantly. Basically a taxi service, which is typical for kids this age. Yes.
And how would that look?
What?
How would that look? Would you pick them up? Were you picking them up from school?
Pick them up from school, take them to the activity. Children are both in different schools now, so you have to go to the other school and get the other child, take them to their activities. So yeah, I mean, like I said, it's a glorified taxi service.
So if the children are going to their extracurricular activities now, what is the basis for your claim that you still missed time?
For example, using piano as an example, kids have been in piano for, I don't know, a year and a half or so. I did a duet with Maddie, I don't know, about a month ago. I'm doing a duet with Daniel here in a couple of weeks. I actually stay at the piano practices, and I'm there with the kids, talking with Nancy, the teacher, and interacting and being with the children. I'm being deprived of that because Alexis is claiming that it's her time even while she's at work. So it's not the kids, you're not like shuttling the kids somewhere and dropping them off and leaving them for a half hour or whatever to do their activities. I'm integrally involved in literally almost every activity the kids are involved in.
And did you incur attorney fees in the process of the show cause motion and pursuing the time and all of these hearing dates?
I have.
All right. And do you know your final balance yet?
We're still going, so I'm not sure.
I have no further questions.
Okay.
Follow up, Your Honor?
Yes, you can have recross.
You're not suggesting, Mr. Tabaka, that you would have, under the order, the right to have makeup or parenting time with the children in the evenings or the mornings when the defendant, when Ms. Tabaka is working, are you?
I'm not sure what your question is.
Well, you said you didn't know how to figure the order when she worked at 2 o'clock in the morning or 10 o'clock at night. The order doesn't allow you to have the children during those times, correct?
The order states if she is working, then I get parenting time.
It says in the morning or the afternoon. Are you interpreting the afternoon being at 10 o'clock at night or 2 o'clock in the morning?
I don't know. Does 5:30 count? I mean, I shouldn't be asking a question. It's 5:30 in the morning. I mean, with my kids, probably not. 7 o'clock in the morning. Yes, because they're awake. So again, it's a fine line, and there are no specific times, as we covered earlier in the order.
All right. Okay, very good. You have usurped some of the time that Ms. Tabaka had at the pickups of the children, have you not?
I have
Objection.
usurped.
Was there an objection, Your Honor?
Objection vague.
Okay, what's the basis of the objection?
Vagueness. He says you usurped time at pickups. I mean, that's
Okay.
how.
Maybe you could clarify, Mr. Schaefer.
There are times when Ms. Tabaka's time is to pick up the children at school, and you have taken the children from school and gone elsewhere while she waited to pick up the children.
Objection relevance, Your Honor.
Relevance as to clean hands when you're asking for show cause, Your Honor, if in fact he's violating the order.
Your Honor, there's been.
Now, I'll give you a little leeway, Mr. Schaefer, but that's all. So just a little.
Okay. Okay, that's all right. One question. There are times you would take the children from school when Alexis is to pick the children up and you're down at some other property with the children. Is that not true?
In what time period, sir?
Well, I guess the time period that we're here on, and you filed this in July of 22, during that time and prior back to 2015?
Your Honor, I would ask that the question be narrowed. He can't answer.
Yeah, I think so. Please narrow the question, Mr. Schaefer.
Have you taken the children down in May and June of 22 the school on the days that Alexis is picking up the children?
Your Honor, again, if he could point to specific dates, but it's too vague just to say May or June. Did you pick up the children when she was supposed to?
It's narrowed down in 2 months, Your Honor. It's just he shouldn't be able to remember in that time frame.
Well, if he can remember.
Do you recall?
Do I recall taking the children in May and June of 22 from school and gone somewhere? No.
Gone down to one of your rental properties near the school?
No, I have not. I'm with the kids after school sometimes. I wait there until Alexa's mother or Alexis shows up and they go right to the car from there. So no.
Why are you at school with the kids on that time period? It's not your designated time period to the kids.
Objection, Your Honor. This is going, I think, outside the court's leeway.
Mr. Schaefer, what's your response?
Well, this has been a cluster of a long period of time and trying to figure out what these people are doing with the children. And he is complaining that he doesn't have any time with the kids or certain time with the kids that he should have. But the truth of the matter, and I proffer, is that he has a lot of time with the kids and it lops over into my client's time and an inconvenience to her in that regard. That's the point I'm trying to make.
Well, you can argue that point. I think we can move on from there. I don't think maybe the subject of this, or I guess you'd say the parameters of this proceeding would take into account that, but I think you've made your point, Mr. Schaefer.
Okay, very good. If I may have one moment, Your Honor.
Yes.
Mr. Tabaka, prior to filing this complaint, had you scheduled the children for activities that were on Alexis's designated time in the order?
Again, Your Honor, objection. That's not at play here. If Chris is alleged to have violated an order, they can file their own motion.
Well, except it goes to clean hands, Your Honor. I don't think it's appropriate that if in fact he is violating the intent of the order that he gets the benefit if he doesn't have clean hands.
Well, as I did with Ms. Elaine, I confined her to the petition, and I'll confine you, Mr. Schaefer, to your answer. You didn't allege, again, unclean hands or any usurping by the defendant of the plaintiff's time, so I'm going to sustain the objection.
I have no further questions, Your Honor.
Okay, thank you. Well, the attorneys are going to have to help me then. Where are we at as far as proofs in this matter? We've jumped around so much. Ms. Elaine, did you have any additional witnesses?
I do not, Your Honor. I rest.
Okay. And Mr. Schaefer?
Well, I think I'm going to wish to call my client in response to some of the things that came out in cross of Mr. Tabaka, just because it was out of order. So I make that request.
Okay, so you're calling him for rebuttal purposes?
Yes.
Okay.
There have been a lot of testimony from both of you folks about these various dates and times. And I guess the last testimony I heard from Mr. Tabaka that he is relying on a June 21 general request to have children on particular days. The days that we had talked about, did you ever get specific requests on those days that he was going to want the children?
Asked and answered at the last hearing, Your Honor.
I'm following up on the cross of Mr. Tabaka.
I'll allow it. Go ahead.
Yes. Did he ever give you the specific request for days that you were working when he would be entitled to the children, other than his June of 21 all-encompassing request?
There were only 5, maybe 6 total days where it was for a specific date out of all of the dates listed.
Okay, and that is encompassed in our chart response exhibit. Is that correct?
That's correct.
Okay. What is the travel time between where you lived in Harper Creek area and Denny's?
The travel time from my home to Denny's, 15 minutes one way, 15 minutes back. So half an hour round trip.
Okay. Do you believe that Mr. Tabaka is entitled to any make-up time based on the order that was entered in 2015?
I would say that for the dates where he specified a specific date, that I would call that was advance notice for that date, and then we can look at those dates. I believe that could be valid. But with everything else, I can't make plans for my children at all if ever under the way he's trying to interpret that order.
Okay. Have you made efforts to have Mr. Tabaka have contact with the children, allowing to have contact with the children?
Objection, Your Honor. First, that wasn't part of my Dr. Tabaka's examination, and second, it's irrelevant.
Okay. Mr. Schaefer?
I think it certainly is part of his examination, Your Honor. He gave the impression that she was going out of her way not to make the children available to him.
Well, I think there was an objection on that, and I don't think we really allowed her to go in, or him to go into that. So please move on.
Okay. I have no further questions, Your Honor.
Okay. Any, I guess you'd say, do you have any cross on the rebuttal, Ms. Elaine?
No, Your Honor, I don't.
Okay, thank you. Okay, with that, anything else, Mr. Schaefer?
Nothing further.
Okay. Ms. Elaine, did you have any rebuttal?
No, Your Honor. The only other outstanding question, and I would like guidance from the court on this point, is how you handle the attorney fee issue. Since we are not done incurring attorney fees, does the court request a separate hearing, or will it give us a timeline to submit a bill of costs and have a response? Or
Yeah, if that's granted, then you would have a right to submit that bill of costs, and the court would then consider that as a subsequent hearing.
thank you, Your Honor.
Okay. It looks like all of the proofs are in this matter. So, Ms. Elaine, do you wish to make a closing argument?
Yes, I do, Your Honor.
Okay, go ahead.
Your Honor, I think the proofs have shown quite sufficiently exactly how the parties interpreted the order. And I think that the proofs have shown definitively that the parties interpreted, knew, and operated under that provision as it allowing to have Dr. Tabaka to have the children anytime that Alexis worked. There was no need for Dr. Tabaka to tell Ms. Tabaka every single evening before the next day that he wanted the children the next day. That is how they operated. That is what they did. That's how they understood the order. She admitted at great length, actually, why she stopped doing that in June of 2021. She went on, and this is on page 19 through 21 of the transcript from the first hearing, that she said, "For the welfare of myself and the children, because of how uncomfortable things had become between their father and I was essentially flexing my schedule to be able to take the children pretty much to school by myself. So we weren't having this unnecessary child exchange in the morning before school, where I had to be in the presence of a man who was trying to hurt me and take my own children from me." And as this court will recall, that was directly after Dr. Tabaka procured an ex parte order that their children should not be around Alexis's boyfriend. That made her angry. That is why and when she decided to stop honoring the parenting time provision that had been exercised faithfully for 6 years, giving Dr. Tabaka daily time, near daily time before and after school with these children, and all summer long while she worked. And I think it's important to note what a detrimental effect that change, her unilateral decision out of vindication for a court action that he took, has taken on the children. She was impeached, if you recall.
Your Honor, I'm going to object to this line. I don't think that those issues are before this court. This is a interpretation of an order, and this is going far afield for emotional reasons.
Well, the court is going to allow leeway. It is closing argument. I'll consider what the proofs demonstrate. Go ahead.
It's all part and parcel, Your Honor, of her admitting in a lot of other forums that she knew exactly what she was doing, that she knew how the provision was supposed to operate, and that she stopped operating it. In the same manner after that ex parte order was procured. She admitted, and I went through the chart and I went through the transcript, and other than the the August 2nd through August 6th of 2021 dates, which my client corrected today, she admitted every single time that we had on our chart, and I've got the page number corresponding to the makeup time hours owed, that she worked, or that she worked actually. And her excuses are invalid. Her excuses, while numerous, have been that, well, she made other plans for the children. The order doesn't say that she's allowed to do that. She has said that he didn't ask. We already dealt with that, but that just wasn't their standard. And that the order, it should be very clear, the order does not say that he has to ask every single day. It says advised of defendant's plans in advance. That's all it says. And it's unreasonable to assume that when he isn't asking every single night for 6 years, that all of a sudden he has to start asking every single night. The reason he started asking on those specific dates later in time that we showed today was because by then he had been advised of her position that she was going to take, that her proper interpretation was that he had to ask every single night. So he's like, well, I'll start asking every single night. But that's not the way the order was written. And that's certainly not the way that he exercised it, or they exercised it together. Your Honor, you've heard other excuses like this was a temporary order that was supposed to end at preschool. I think the record stands that this order is the one that's in place. It doesn't matter what you call it. Of course, it was a final order, but that is a non-issue. That it was only meant to apply through daycare. Obviously, they never stopped exercising it. Everybody understood the provision to be continuing in nature. This court already rejected the excuse that he had to divulge his specific plans. And Alexis also testified at length that they were just operating under a civil co-parenting agreement. And that was her way of evading the truth of the matter, which was she was operating under a specific provision in the judgment that she then decided not to implement. She said in page 73 of transcript 2 that she had complied with the provision. So she's acknowledging that what she was doing was compliance with the provision. Again, Your Honor, if you just look at the chart and the hours, which when we went through November 3 of 2022, there was no argument made or objection made to considering those times. So we would ask the court to consider the full chart of parenting time hours. We established that they were 211.25 minus the 28, which would give Dr. Tabaka the remaining time. Your Honor, with regard to her working remotely, this court should not accept an argument that because she worked from home, she didn't work. Because of course, if you're working from home, you're working. And the whole point of the provision was so that the children could have care. I mean, that's what parents do these types of provisions for, so that the children are occupied and engaged and have a parent caring for them. Alexis testified that she answers the sheriff office phones during her work hours. So she doesn't have a job, and it wouldn't matter anyway, but she certainly doesn't have a job that just allows her to care for children and, for lack of a better phrase, phone it in to work. If she was working, she was working. And this court should not grant her any leeway for, quote, working at home. It was clear that she started working from home when this issue arose and she was trying to evade the strictures of the parenting time agreement. I would also think it's compelling that despite her excuses for it, every time Dr. Tabaka did ask her in our family wizard for time, and all the times, 25, 30 times that he said, I want to exercise my time according to the agreement, I want to exercise time while you're working, and he kept saying that to her, she never once said, that's not what the agreement says. She knew it. What she gave back to him, her response was, no, I have the children, which got her out from under the operation of the agreement, which if she isn't working, she's right. She doesn't have to turn them over. But that's indicative of her knowing the only way that she didn't have to comply with it was not working. So she responded on that note, I'm not working. I'll have the kids all day. Some of the time she did, some of the time she didn't, and those are clarified on the timesheets. So that's why all of that information is relevant. Any other person who didn't believe that he had the right to have the children would have said, what are you talking about? You don't have the right to have the children. But she never said that. She just said, no, I'm not working the next day, or I'll be with the children all day. Accordingly, Your Honor, we ask that the court find that Alexis is in contempt of court for violating the court's order. We asked in the original pleading for a sanction against her of $500, and Your Honor would take up the attorney fee. If contempt is found, Your Honor would take up the attorney fee issue later. We would also ask that we are awarded all our reasonable attorney fees for pursuing this violation. And we ask that you grant Dr. Tabaka the makeup time that he has requested in the amount of 211.25 hours minus the 28. Thank you.
Thank you. Mr. Schaefer, closing?
Yes, thank you, Your Honor. I would respectfully suggest that the Alexis is not in contempt of the court's order. This has been a long, arduous process. There was a time when these parties were able to co-parent and be civil to each other, and there came a time when, in fact, that ceased. And it ceased for a different reason than it was argued by the other client. It was ceased because Mr. Tabaka changed his attitude for a lot of reasons. That Mr. Tabaka declined to work, he got remarried, had nothing to do with the Kyle incident. And in fact, that has spun into a couple of more hearings that are pending that are not subject to this matter here. It became an abusive relationship from Mr. Tabaka toward Alexis, and all detrimental to the children. And that will be addressed in the other hearings. But as it relates to this particular order was in 2015 when the children were in preschool. And in all due respect, it was fashioned for the preschool, just the reading of it as to the points and so forth. If the court is, and it says it's a temporary order, if the court is dealing with this as to what the literal language is, fine. That is, my client has made every effort to comply with the literal requirements of this order. This order is deplete in specificity when it talks about afternoons, mornings, with no dates, times as to when the eligibility would take place. That is subject to interpretation, it's ambiguous in that regard. My client made every effort to comply with this, and she realized that what Mr. Tabaka was doing was trying to set her up for this particular hearing. So she, in fact, did not work on many of these occasions when she got a reasonable request. In all due respect, a blanket request in June of 21 is not advance notice under this order. I don't think it's reasonable to believe that. People have lives, and if in fact there needs to be a notice of the plans, I think it has to be in close proximity to the time that is requested. But in spite of that, my client did adjust her work schedule so that she was not working on these particular days for reasons that are beneficial to the children. That will be addressed later. But she complied with the order, even though she believed that the order was in relation to the time when the kids were in preschool. But the attitude and the position of Mr. Tabaka changed in that regard. She complied with that and has filed a motion to adjust the parenting time, which will be heard later. The time periods that are suggested that he gets credit for are not reasonable. He is suggesting he gets a half hour here, an hour there, and the exchange point is that he wants my client to drive 15 minutes from Battle Creek to Denny's and 15 minutes back so he can have an hour with the children. Mr. Tabaka, as indicated, has positioned himself to have an enormous amount of time with the kids, and that he is at their school all the time. And that is
evidence.
Go ahead. It's just argument.
It is evidence based on the testimony of Mr. Tabaka, Your Honor. And this situation has morphed into an absolute debacle from the standpoint for the benefit of the kids. And my client is the only working parent in due respect to these kids and is making it difficult for her to comply. She has complied. She's adjusted her schedule. She worked nights, as she testified to, late at night, early in the morning, just so that she would be available for the children and would not be working, and thus complying with the order. And that what has been submitted as her rebuttal chart to the chart. If there is some time that Mr. Tabaka is entitled to for makeup. I don't believe there is any, but it's a minimal amount at best. I don't think he's entitled to his 4 hours, 5 hours, whatever it might be on particular times, because there's no beginning time, there's no ending time. It has to be a reasonable approach to this order. The order is not in a vacuum. It's all the other turmoil that is going around. And if there's not specific times, if it doesn't say from 8 o'clock to 12 o'clock, then it becomes interpretation of the parties that are dealing with the problem at the time. Your Honor, I don't believe that there was any intent of my client not complying with the order. She made every effort to comply with the order. She was dealing with a harassment situation. She was trying to deal with the kids. She has complied best she can. And there is very little time that she had to deal with making the children available, because there was not reasonable notice for the time period that Mr. Tabaka wanted. What is telling in this particular matter is that Mr. Tabaka says the pickup place was not significant. He never went to a pickup place. He was saying, well, we picked up at school, we dropped off at school, whatever. But the exchange point is if there is an agreement. If there's no agreement, then the order is clear that where the pickup places are. He never went to the pickup places at any time to enforce what he thinks he was entitled to. And I think that is a requirement of the order, the totality of the order, if it's being interpreted in its totality. Your Honor, I would ask that Mr. Tabaka not be held in contempt, and that the other relief be denied. And also, I think that the parameters of this suit is the date that it was filed. That is in July of 22, not November of 22 or any other time. It is the dates that were pled, because that is what we had to answer and deal with. So I ask the relief that there be no contempt, Your Honor, and that perhaps there be clarification for future compliance with this particular order. Thank you.
Thank you. Ms. Lane, any additional?
Yes.
Pardon.
Yes. Well, this is the first I've heard now that she changed in June 2021 because Dr. Tabaka has, quote, declined to work and got married, and that's the reason. That's the first time that came up, because what's happening is the more that we have shown she actually did violate the order, the more she tries to generate an excuse. And it was mentioned in closing, Dr. Tabaka became abusive, and that's why things changed. Well, according to Ms. Tabaka, he was been abusive all along, which of course he denies. But read our family wizards that we submitted. Where's the abuse? Where's the harassment? He's very diplomatic and kind when he speaks to her. So that should be disregarded in its entirety. I also want to address the repeated claim that the order says preschool. It says preschool/school. That's what the order says, preschool/school. So it isn't correct that the order was just to apply to preschool. Mr. Schaefer argued that the order is not specific as to date and times. I don't know if the suggestion was, therefore, this court can't enforce it. But the parties had their schedule, their parties had their routine. And that is what Dr. Tabaka went off of when he created the violation list. He went off of the hours that she worked as standard practice, as their historical practice. So he could have gone earlier in the morning to 7:30 or whatever, but he was just trying to keep it simple and go with what they were exercising. What they were exercising was her work hours. And when she was working 8 to 4, then those are the hours he would have considered missed when he didn't get them. If she was working 9 to 5, then those are the hours he would have considered missed. And that's how he made those calculations. With regard to this advance notice idea again, and people have lives, this was a no-brainer operation for 6 entire years. That's again a newly manufactured excuse that she has a life. Therefore, she can't turn over the children while she works. I mean, if she's working, she's working. That's her life at the moment. Finally, Your Honor, how can he appear for parenting time at an exchange place when he doesn't know he was actually entitled to the children that day, in that particular time? That would require supernatural skills on his part. The only way he found out that order had been violated and which specific times he would have been entitled to have the children were after he got the records showing that. So, Your Honor, again, the total hours are 183.25. Those are the hours that were on Exhibit E. Again, that wasn't objected to. We spent a lot of time at the last hearing going through that ad nauseum. So I hope that the court will consider that 183.25. And Dr. Tabaka would like to exercise that in 13 Sundays when he doesn't otherwise have the kids for 10 hours. And 10 Fridays where he doesn't have the children already for 5 hours. So I believe that, and then an additional Friday for an extra 3.25 hours. That's how that calcs out.
Yeah, I guess I'm going to object to this. This is something that I apparently am not going to have even a chance to respond, and it wasn't testified to, so I place an objection in that regard.
That's fine. It's closing argument. I'll allow you to go.
Thank you.
That's all, Your Honor. Thank you.
Okay, thank you. Well, what the court's going to do, I'm going to take a brief recess. We'll reconvene at 11. I wanted to look through the testimony of today. I've got all the stuff. I've looked over it numerous times from the past hearings, but I want to mesh this or whatever with the prior testimony. So what we'll do is take a brief recess till 11 o'clock. Mr. Schaefer, if you want to stay on, you can simply mute yourself, and Ms. Elaine will put you and your client in a breakout room if you wish, and then we'll bring you back. We find ourselves in throughout these proceedings, and that the parties had such a good relationship previously. They were able to work things out, and apparently that worked out well for the children. And in this particular matter, the matters before the court on the defendant's motion to show cause and for make-up parenting time filed on July 8, 2022. Motion claims a violation of the order of custody support parenting time and preschool/daycare from 11/3/2015. The order provides the parties with joint legal custody and the physical custody to the defendant, and provides for parenting time to the plaintiff and parenting time to the defendant on specific times that are not in dispute in this particular case. What is in dispute is the language contained on page 4 of the order, which states, and I read, it's a note in, well, page 4 and 5, it notes, defendant may take the children for afternoon parenting time and the youngest minor child for morning parenting time, and both children on 5 days, subject to provisions stated herein during such time as plaintiff is working, so long as plaintiff is advised of defendant's plans in advance. I've already addressed the issue as it relates to so long as plaintiff is advised of defendant's plans in advance. The court takes that as his plans to take the children or not take them, and I'll address that in a moment as well. The court will note that this provision has never been modified by the party. The provision has 2 conditions: that plaintiff is working and plaintiff is advised of defendant's plans in advance. The plaintiff testified that she interprets this provision as requiring defendant to inform her of his parenting time plans during the parenting time, meaning what will he do with the children during the parenting time. This condition requirement does not appear anywhere else in the order. Court will find that the plaintiff's interpretation of requiring to know what he is doing during those parenting times is unreasonable and not a fair interpretation of the order. This provision provides for additional time during such time as plaintiff is working, with the logical interpretation to be that defendant would advise plaintiff of his plan to take the children during the specific times in advance of his taking them. It should be noted that at no time has either party sought a modification of this order or an interpretation of this provision. In fact, the parties, based upon both of their testimony, did not have any disputes concerning this provision until June of 2021. During the 6-month period, the 6-year period, the defendant exercised his additional parenting time and more, taking the kids to school on a daily basis without incident. In June of 2021, however, the plaintiff was asked what defendant had done to cause a change. Plaintiff testified, and I quote, defendant contacted CPS to take custody, end quote. She further testified, defendant filed multiple CPS complaints and filed an ex parte motion to take custody. During the 6 years that the parties were getting along, defendant exercised this additional parenting time. Plaintiff testified there was no dispute about this provision. She never told the defendant was not exercising his parenting time. She never denied defendant parenting time while she was working. After the CPS complaint and the motion for ex parte relief, plaintiff informed defendant that she would be taking and keeping the children during her times. Defendant, in turn, set defendant's Exhibit D on June 28, 2021, stating that he was exercising and would exercise all of his parenting time. Many disputes about the 11/3/2015 order have arisen since that time. Court finds many deficiencies to the interpretation and the application now that the parties are going through as a result of that order, and I'll address those in a moment. Defendant's Exhibit A was admitted. It was a 57 pages, will reflect the times plaintiff worked from 3/12/21 through 11/3/22. Plaintiff submitted plaintiff's Exhibit 3, which is her response to the defendant's exhibit as to the denial of the parenting time. Plaintiff's Exhibit 3 identifies the hours worked, what she was doing with the kids, and requests from the defendant for the children. During the time that the parties were disputing parenting time, we also were faced, unfortunately, with the COVID pandemic. And again, plaintiff's work was shut down for a period of time, and thereafter she was authorized to work remotely. Plaintiff's Exhibit 3 reflects the time she was working remote from home. Defendant was not dispute the testimony that she was working from home, and she worked various hours, sometimes in the evening, sometimes in the middle of the night when the children were sleeping, or other times during the day. The court believes that the intent of the provision in the order providing for this additional parenting time was to provide the defendant with parenting time when plaintiff was at her workplace and was not with the children. As a result, the court will not apply this provision to the times the plaintiff was with the children and working remotely from home. Plaintiff's Exhibit 3 delineates her response to each date that the defendant alleges he was denied parenting time with an explanation of what the children were doing and whether she received advance notice. Just as an example, on 6/18/21, or 4 hours, plaintiff testified defendant sent our family wizard request, and that's in defendant's Exhibit E, that he was working at the John Ball Zoo and wanted to take the children with him. The court does find it interesting and again, perplexing as to why it was appropriate for him to take the children on this particular event when he was working, obviously in a different town, and that it would not be appropriate for the plaintiff to have the children when she was working from home. The plaintiff had testified on this date that she did not allow the defendant to have the children because there were prearranged plans with the paternal grandparents. On 1/21/22, there were 6.5 hours that were in dispute, and defendant made a request through our family wizard, and defendant's Exhibit F shows that school was canceled and the children were with the maternal grandmother. On 7/1/2022, 6 hours, defendant sent our family wizard request dated 6/30/2022, and the plaintiff's exhibit states failed to communicate any plans, prearranged theater arts plan with paternal grandmother. On 10/12/22, there were 3 hours where defendant emailed plaintiff on 10/11/22 through our family wizard that he wanted to take the children. Plaintiff states defendant did not provide plans and she had prearranged the afternoon plans, and states that it was a play date and that she worked until the play date were over. Well, in this particular matter, any other plans where she had with paternal grandparents, maternal grandparents, or other dates would in fact not be appropriate under the order. She can't simply make other plans because she wants to, because effectively she could make plans every particular date that she was working from the office, and then it would be a nullity of that this provision would be applied in any event. So the court will consider those particular times when she did have other plans when she was working from the office as a violation of the order and a wrongful denial of parenting time. Court will note as well that, again, during these times that I've mentioned, there were 19.5 hours where defendant gave specific prior notice and was denied parenting time. The plaintiff has acknowledged and admitted that she received the advance notice on these dates, and she was aware of the provision in the order providing that he would have the parenting time on advance notice. Court will note, and the defendant has brought up a good point, is that there are other parenting times that were missed because he was not aware of when the plaintiff was working, and she acknowledges herself she didn't inform him of when she was working on these other dates. And she acknowledges as well in her testimony on today's date that there were approximately 5 to 6 specific requests that were made in this particular matter. The court believes that based upon the testimony in this matter, that there were at least 20 other hours other than the 19.5 that the courts identified previously where she was working, and the defendant did not have advance notice of the work that she was working, and that there should be make-up parenting time during that particular time. The court would note as I go through these hours that it was pointed out today that at the last hearing, we did address the denial from 7/8/22 through 11/3/22 without objection. As a result, the court is, and I will address the time through 11/3/22, again, to avoid having to come back for that period of approximately 4 months, but also the fact that, again, without objection, the court did take testimony on that particular period of time as well. Michigan compiled laws 600.1704 parens G provides that a party may be held in contempt of court for disobeying any lawful order of the court. MCL 552.601 at SEC, the Supported Enforcement Parenting Time Enforcement Act, also provides for that relief. Plaintiff had notice of the order. She again acted for 6 years in compliance with that, and court will find that she did act in willful disregard or disobedience of that order in denying the parenting time for 39.5 hours. The evidence shows clearly and unequivocally that she is in contempt of court for this particular time. Unfortunately, the judgment was poorly drafted, and it didn't identify how and when notice would be given and what hours the defendant would be entitled to, and that became very clear the other days, but also in today's date with the testimony. Court does not believe, however, in this matter, and that's why I've limited the hours, does not believe that a generalized statement given months or years in advance that the defendant intended to take the children was sufficient notice as provided for in the judgment, where the plaintiff had to be advised of his plans in advance, meaning the plan to take the children. Court notes that a statement given many months or years in advance, where the plans or schedules may change, puts the children at risk of not having proper supervision. What the court will do in this matter, the court will modify the provisions of that November 3rd, 2015 order to provide that the plaintiff is required to give defendant notice no less than 48 hours as to when she will be working from the office and not have the children in her care. And defendant will then give plaintiff notice of his intent to take the children no less than 24 hours before when he is going to be taking them during those particular times. Should plaintiff fail to notify defendant 48 hours ahead of time, then again, he shall be entitled to have the children with him during those particular times, which would be, again, that particular Friday. Should defendant fail to notify plaintiff of his intent to take them at least 24 hours ahead of time, he forfeits the right to take them. There were dates, as we've noted today, there were dates in August of 2021 where a plaintiff was on vacation with the children, and court notes that today's date, the defendant did stipulate that those 28 hours should be removed from his calculation because, again, that vacation period of time was arranged and agreed upon between the parties previously. The court will therefore find that there was not a wrongful denial of parenting time during this particular time. Additionally, in early November 2021, the children were quarantined because of COVID. And as the defendant testified today, he had COVID, they had COVID, et cetera. The court will find that this period of time was not a wrongful denial. There are also times alleged that where there was a half an hour or an hour where the children would have been exchanged for minimal time, but in fact, effectively, the transportation time would have eaten up all of this particular provision or this time when he would have had this time. The court will find that it would be, again, not the intent of the provision of the order, it would be nonsensical to award him this particular period of time when the children would simply be in transportation. So what the court is going to do is the court will order a makeup parenting time of 39.5 hours that he can take either on a Friday for 5 hours, as he previously, as his attorney asked for, or on Sunday for 10 hours when he would not otherwise have the children. And the court will order that this would not occur, again, if these were on a holiday, because they should be commensurate with the time that was lost in this particular matter. Court will note that Michigan Court Rule 3.206 parens D parens 1 parens B allows for an award of attorney fees and costs incurred because a party refused to comply with a court order despite having the ability to do so. The court finds that the plaintiff did refuse to comply with the prior order of the court, although she had the ability to comply in this matter. As a result, the court does believe that an award of attorney fees is appropriate in this matter and will allow the defendant to tax his cost. However, the court will note that he did not entirely prevail in this matter, and in fact, had been awarded substantially less than the hours that he had requested. And again, the court, as a result in this matter, is going to consider and will only award to the defendant 1/2 of the attorney fees incurred in pursuing this matter. And again, that's subject to the taxing by Ms. Elaine. And if there is objection, we'll address that at that time. When in fact the court does make a final determination on that amount, the court will rule that that amount would be paid within 90 days of the order allowing that particular final taxable amount. Court would order that the makeup parenting time of 39.5 hours would be taken within the next 6 months from today's date at the times requested by the defendant. Court does note that, again, I believe that does resolve all of the issues before the court today. I'll ask Ms. Elaine, is there anything you believe that the court failed to address or needs to address before we conclude?
Thank you, Your Honor. I do have a couple of questions of clarification, if you don't mind.
Okay.
So in getting to the 39.5 hours, you did not include any time in which it was indicated that Ms. Tabaka worked remotely?
From the time that she worked remote, it had the children in her care, correct?
Okay, so those hours are not included. We know the 28 hours of the summer parenting time were not included. And you nixed.
I didn't allow the time of the period of COVID, nor the limited hours where it was 1/2 or 1 hour where it would have been nonsensical because of transportation. That is correct.
And no COVID. Okay.
And the court did note as well, I did take into consideration other times in arriving at this number, other times when the defendant claims a denial that he wasn't informed by her that she wasn't working, so he would have known that.
Did you?
That's more of a nebulous number, I guess, and that's how I just based upon what I saw, that's what I came up with.
Did you eliminate hours where you didn't find he had made a specific request?
Yes, I did. Because as I stated, a generalized request made from, again, June of, I think it was 2021, would not, again, advise the plaintiff of the plans for the parenting time. So I, in fact, denied that time as well.
Would that include even the times right after he sent that Our Family Wizard? Like those?
No, that's why when I referenced specific dates as examples, those were times when he did give specific dates or specific requests. And then she also testified that there were 5 to 6 times when he made that additional request. So I'm taking that into consideration.
Okay. And then on your, on the modification of the provision, I had a question about that as well. I understand that she is to provide him 48-hour notice. 1 second, I just have to find my notes.
Of when she will be working
Yes, from the office.
from the office. And obviously not remote, not having the children with her because she wouldn't have the children at the office.
Right. And then I didn't understand the second part of that. You said if plaintiff fails to notify defendant, he will be entitled to have the children with him, but I'm not sure I got that down right.
Correct. If she doesn't, if it turns out, he finds out that she was working and she didn't notify him in advance that he would be entitled to that time.
Got you. Okay. So you're just talking about later.
Yes, because I don't, like before, in this case, I don't know there's any way to know in advance that that's going to happen.
All right. And I assume you considered the fact that she could potentially just work remotely from here forward and nullify the provision that way.
I don't know if she could. If she could, then yes, it would nullify that provision because the court interpreted that provision to mean when the kids wouldn't be in her care.
Okay.
Because it was obviously, it was a result of the COVID change in work schedules, et cetera, that didn't exist, in this particular case, during that 6 years.
Okay. And with respect to the bill of costs, Your Honor, were there timeframes that we should strive to process that? For instance, when would you like my bill of costs submitted?
Would you be able to do that within 30 days?
Yes, Your Honor.
Okay, submit it within 30 days then.
All right. And then the objection time period?
I'll give Mr. Schaefer, I'll give him an additional 30 days. I don't know if he has vacation plans coming up, but that should cover anything where he'd have 30 days to then object if he has an objection.
If no objection.
No objection, then that would be the particular amount.
Okay.
Obviously, I said I've only referred to the attorney fees, but costs as well as to, motion fees and any other of those out-of-pocket costs.
Okay. All right. I believe that's all the clarifications I had.
Okay. Mr. Schaefer, is there anything you believe the court has failed to address or needs to address before we conclude?
Yes, clarification on the makeup time. Your Honor said that the makeup time would be on a Friday or a Sunday, 5 hours on Friday and 10 hours on Sunday. Is that accurate, first of all?
Yes, because he was asking for, again, all the makeup time. He was asking either for 5 hours on Friday or 10 hours on Sunday, those dates that he wouldn't have the children normally. So I've just carried it through based upon his request that the makeup would occur on those particular dates.
Okay, fine. Notice requirement, when must Mr. Tabaka let Mrs. Tabaka know what dates those are? We would respectfully ask a reasonable notice in that regard.
Well, you can take them within the next 6 months, and I'll order that he would advise her 7 days prior to his request to take them.
Okay,
And
thank you.
obviously, if he doesn't make the request within the 6 months, then he forfeits that makeup parenting time.
Okay, thank you.
And that would be 7 days in advance of each individual date.
Yes, yes, correct. Because he doesn't know his schedule. He may choose to take half the time, you know, through whatever letter he would send out, and then reserve for a couple months until the end or something. I don't know.
Right, right.
I think that's the only question I had, Your Honor.
Okay, thank you. Ms. Elaine, I'll ask that you would prepare that order. Yes,
Your Honor, might we have just one moment, maybe one more?
okay.
In relation to the scheduling of the makeup time, my client already has some things in line. And I guess I would respectfully ask that we not disrupt those. We would try to cooperate with reasonable time.
Can't imagine there'd be a problem. What I'll do is state, Ms. Elaine, you can include this, that Ms. Tabaka would have 7 days from today's date to advise him of any plans within the 6 months for vacation or times she might be out of state during those, you know, or be doing something during those Fridays or Sundays, and she'd be able to reserve those out, obviously, provided that it's not all of them such that he couldn't take them during that time.
Right, Your Honor. But I mean, if she only leaves him the ones that she wants him to have, that kind of divests him of any choice in the matter.
Well, what I'll do is state that if she has any legitimate vacation plans where she was going to take them for a period in excess of maybe 5 days, that so she couldn't just pick every Friday or whatever, it'd be a legitimate vacation time.
Okay, that's workable.
Does that take care of it, Mr. Schaefer, do you think?
I think so. There's no intent to block this out, and we'll get that information to Ms. Delane shortly.
Okay, within 7 days of today's date.
Sure.
Okay. Thank you. With that, then, Ms. Elaine, if you would prepare the order, you can submit under a 7-day notice of entry, and we will conclude this matter at 11:36 a.m.